are joining us for a webinar on cancer and the law. Today's goals are going to be giving an overview of health insurance, employment rights, and disability income and how they all fit together. And just to make sure that we're all sort of on the same page here, obviously you're all familiar with the CLRC a bit since you're joining us today, but the CLRC's mission is to provide information and resources on cancer-related legal issues to cancer patients, survivors, caregivers, healthcare professionals, employers, and all others coping with cancer. And we are a program of the Disability Rights Legal Center. Now, I do want to let you know that I am going to try to leave some time for questions at the end. If you have questions, please type them into the question box. And just for those of you who have not participated in our webinars in the past, we do have everyone muted except for me, just because otherwise it would be a little difficult to navigate with so many attendees. But if I'm not able to answer your questions today, like I said, I'll try to leave some time at the end, but this is a lot of material to go over. Don't worry, there is an opportunity for you to follow up with us. We have a national telephone assistance line. The phone number is right here, 843-2572. That's an 866 number, toll free. So you can either give us a call or submit an online intake at clrcintake.org if I'm not able to answer your questions today, or if you have questions that come up in the future, please feel free to contact us through our telephone assistance line. And I do want to give a special thank you to the Tower Cancer Research Foundation for a grant which is making it possible for us to share this cancer and the law information with you today. So let's just dive right into it here. Our health insurance system here in the U.S. can be rather complicated. So first I'm going to go over some insurance laws that provide some protections for consumers. I'm going to talk a bit about healthcare reform, the Patient Protection and Affordable Care Act, and then I'm also going to talk a little bit about some other programs, including Medicaid. So let's start out with an example. Let's imagine Sima. She is a childhood cancer survivor. She was laid off from her job and she has her health insurance for her family through her employer. So now that she's lost her job, she's trying to figure out what her insurance options are going to be for her and her family. Well, one of the things that is going to provide her with one option is a federal law called COBRA. COBRA is a law that provides the opportunity to stay on the same group health insurance plan that you had through your employer for up to 18 or 36 months, depending on what your situation is. Now, one of the things that can be a little daunting about COBRA is that, generally the employer pays a significant percentage of the healthcare premiums, the health insurance premiums. Unfortunately, under COBRA, the employee or former employee becomes responsible for paying the entire premium plus up to a 2% administrative fee. So that's why it says 102% of the premiums. Now, in order to be eligible for this federal law that provides this option, you have to be in a group plan that has at least 20 people in the group. So usually if there's at least 20 employees at the person's place of employment, they're probably going to be eligible for federal COBRA. The good thing about COBRA is that it's literally the same exact group health insurance plan. So you don't have to change your doctors. You don't have to change upcoming appointments. Everything remains the same. You just have to pay a lot more money. Now, another option is that, actually I'm going to go back here for a second. If you work for a smaller employer, depending on what state you live in, most states do have a state mini COBRA plan. For example, in California, if you work for an employer that has fewer than 20 people in the group plan, there's something called CalCOBRA. And it's basically the same thing where you stay on that same group health insurance plan for, it's 18 months if you are leaving your job or have lost your job. And the only difference between, the state and the federal COBRA plans is that under the state policies, sometimes that administrative fee is a bit higher. So, again, you're staying on that same group health insurance plan. Nothing changes except for how much you would be required to pay. So for a lot of people, COBRA is pretty unaffordable. And so for some of those people now, there's a new option, and that's to purchase a health insurance plan through Healthcare.gov. And so, Healthcare.gov or the state health insurance marketplaces are where it's a centralized place where people can go and shop for insurance. There are certain enrollment periods throughout that take place each year. Open enrollment is usually in the fall. But if you've had a major life change, like losing your job or leaving your job, that opens you up for a special enrollment period. So, previously people who were leaving their jobs or lost their jobs, COBRA was really the only option, and if you couldn't afford COBRA, a lot of people had to go uninsured. Now with Healthcare.gov and with the Affordable Care Act, which I'm going to talk a little bit more about in a minute, insurance plans are no longer allowed to deny coverage based on pre-existing conditions. So if you get into a situation where you've had a major life change, you can compare what your COBRA option is to what your options might be under Healthcare.gov or your state health insurance marketplace. So talking a bit about the Affordable Care Act, hopefully many of you are at least somewhat familiar with some of the aspects of this law at this point, since it was passed over 5 years ago now. Some of it still seems pretty new, but some of the major things that took place, some of the major changes that have taken place as a result of healthcare reform and the Affordable Care Act are that lifetime and annual limits are no longer allowed with respect to essential health benefits. So previously, people would have health insurance plans. Maybe they had $1 million policy. Once they reached $1 million, they were basically out of luck. Or sometimes there were annual limits, and some of those annual limits were actually quite low, as low as $75,000, $100,000. And obviously cancer treatment can be extremely expensive, and it was probably quite easy for a lot of those people to reach that $75,000 or $100,000 limit in one hospital visit. One surgery can easily take you over that. So, even though they've been paying their health insurance premiums regularly, once you reached that limit, it was basically like you were uninsured. So those limits are now eliminated. Additionally, health insurance companies and policies can no longer rescind your policy unless there has been fraud or intentional misrepresentation of material fact. That's how they define that. So if you simply, forgot to dot your I's and cross your T's on your application, they can't say, oh, well, you made this mistake, and so we're going to cancel your policy retroactively. If, on the other hand, you lie about your address or you try to say that someone is a dependent who actually isn't, if you're basically straight up lying to them to try to get benefits that you're not otherwise entitled to, that's a situation where they might be able to cancel your policy. Additionally, the Affordable Care Act has made some really great changes for children and young adults. As soon as the law went into effect in 2010, children under the age of 19 were no longer allowed to be discriminated against for having pre-existing conditions, and young adults are now able to stay on their parents' health insurance policies up until age 26. Before, it was often, if they were a full-time student, they could stay on, but maybe only until age 22 or 24. Now, all young adults can stay on their parents' health insurance policies up until age 26, even if they're married, even if they have health insurance offered through work. Another really big change that has taken place is that newer policies, policies that have come into existence since the law was passed in 2010, are now required to offer certain preventive services free of charge. So no copay, no deductible, no coinsurance. And some of those preventive services include things like colorectal cancer screening, if you're, once you've reached a certain age, mammography once you've reached a certain age, cervical cancer screenings, stuff like that. And there is actually quite an extensive list of which preventive services should be covered on Healthcare.gov. Healthcare.gov is a really good resource if you have specific questions about the Affordable Care Act and how maybe it affects you. But there are some exceptions that do apply. Like I mentioned, not all of the protections will apply if you have an older health insurance policy. So maybe you've been working somewhere for a while, they've had the same health insurance plan since the early 2000s, they haven't converted over to a new plan, they might not have to provide those same preventive services free of charge. They might still cover the preventive services, but you might have to pay a copay or deductible. So, keep in mind that the type of policy you have is going to make somewhat of a difference. But more than half of the policies that are currently in existence are these newer policies that do have to comply with all of these new rules. If you're not sure whether or not your plan complies, or if it's an older plan or a newer plan, you can certainly ask your HR person at work, or you can call the plan itself, and they're actually required to let you know whether or not they are what's considered grandfathered. I'd say the biggest change that we've noticed, which I already sort of mentioned here, is that as of January 1st, 2014, insurers are not allowed to consider pre-existing conditions, either physical or mental, when determining whether or not to provide you with health insurance, and also when they're determining how much to charge you. They can't consider any of these things at all. So pre-existing conditions, health status, medical history, genetic information, they can't even consider your gender. And traditionally, women had paid more for health insurance than men. So now they can't even take that into account when they're determining how much to charge you or whether or not to provide you with insurance. So that's been a really big change for people who have a history of cancer or any other pre-existing condition, obviously. Traditionally it was very difficult once you got sick to sign up for insurance. Now, one of the most controversial parts of the Affordable Care Act is probably the individual mandate. And that was a part of the law that was challenged and upheld by the Supreme Court several years ago now. But the individual mandate states that most U.S. citizens and legal residents must have health coverage for the majority of the year. They have to have some sort of health coverage that meets a minimum requirement that the government has set out. Now, short breaks are okay, and by short breaks we mean 3 months or less. So, if you're switching jobs and you have a little bit of a break, or you want to change insurance policies but you miss a month here or there, it's not going to be a big deal. There are also certain exemptions, like if you have certain religious exemptions, or if you don't make enough money to have to pay income taxes, there are certain exemptions from the individual mandate. But for the most part, Most U.S. citizens and legal residents have to have health coverage for at least 9 months out of the year, or they face a penalty. So a bunch of people discovered that this penalty was a thing that existed once they started trying to file their 2014 income taxes. So hopefully many of these people realize that the penalty is not necessarily worth it. For 2014, it was either $95 per adult, $47.50 per uninsured child, or 1% of the person's income, whichever was higher. So, a lot of people thought it was just, oh, $95. Well, $95 is cheaper than paying for health insurance. But if that person got sick during the year, obviously any of their doctor bills would have cost a lot more than $95. And those penalties are going to be going up for 2015. So, keep this in mind if you are currently uninsured or if you have friends or family who are currently uninsured. They should beware that they might be facing tax penalties at the end of the year if they're not able to show that they had some sort of health coverage. So one of the things that was supposed to make it somewhat more affordable for more people to purchase insurance is the idea of these premium subsidies, these tax credits that lower a person's health insurance premiums depending on their income. So if you have income between 100 and 400% of the federal poverty level, and 400% is about $47,000 for an individual, about $95,000 for a family of 4. If you make less than that and you're looking to purchase insurance, it might make sense for you to look to purchase insurance through Healthcare.gov or through your state's health insurance exchange, because you might be eligible for tax credits that would lower your premiums. Now, usually the way tax credits work is that, you go to file your taxes, you put in what your income is, you do your deductions, you put in your credits, and that all sort of works out at the end of the year. The way that these tax credits works or premium subsidies work is that when you are applying for health insurance, you put in what your expected income is going to be for the upcoming year, and then they tell you what your tax credit will be, and then they prorate it throughout the whole year, lowering your premium payments each month. So it's something that takes place sort of ahead of time, and then once you file your taxes, if there's been a difference in the income you anticipated and the income you actually had, that's where it sort of works out. So it's really important if you are getting these tax credits, if you have a change in your income, you have to make sure that you update Healthcare.gov or the state exchange so that they can recalculate what your tax credit would be. If you do have employer-sponsored health insurance, or if you're eligible for Medicare or Medicaid, you're not eligible for these premium subsidies. So that's something to keep in mind. So another major change that took place here with respect to the Affordable Care Act is Medicaid expansion. Now, the original goal was that it was going to take place in every state. So previously, in order to get on Medicaid, you had to have very low income, very low assets, so money in the bank, property you own, stuff like that. And then in addition to that, you also had to meet some other sort of eligibility criteria, such as being disabled or being pregnant or having dependent children or being over 65. So it wasn't just a health care option for low-income people. You had to be low income and also have one of these other situations going on. The goal of Medicaid expansion was actually to make it so that you didn't have to have one of those other eligibility criteria going on. You didn't have to be disabled or pregnant or over 65. The goal was to make it so that anyone under a certain income level, which is 138% of the federal poverty line, which is around $16,000 per year, would be eligible for Medicaid. Now, that Supreme Court case that I mentioned earlier about the individual mandate, in that case, the Supreme Court did say that, the federal government was not allowed to require states to do this because it would have required them to accept federal money. Instead, it made it optional. And at this point, I believe 30 states have opted to expand Medicaid. So in those 30 states, if you are under 138, if your income is under 138% of the federal poverty line, you are potentially eligible for Medicaid. There are, I believe, 2 states right now that are still talking about whether or not to expand Medicaid, and the rest have decided not to expand at this time. So, if you have questions about which states those are, I'm happy to look into that. There are many that I know right off the top of my head, but for the most part, most states have opted into this Medicaid expansion, but there are a few that are refusing to do it, and a lot of it seems to be a red state versus blue state situation. So, it is a really good option for a lot of people in a lot of states, but some of these states are sort of leaving their uninsured populations to basically suffer because if they're making enough money to be eligible for Medicaid, that means they probably can't really afford other insurance. Okay, so what are Sima's options? Well, she should probably check that her employer notified her plan that she has, lost her job. And then she should look and see, whether COBRA makes sense for her finances or whether it might make more sense for her to purchase a plan through Healthcare.gov. And if her income has dropped significantly, depending on what state she lives in, she also might potentially be eligible for Medicaid. She should also strategize for finances and future insurance after COBRA ends, because if she does choose COBRA, she needs to keep in mind that it only lasts for 18 months generally. Okay, so now we're going to switch gears a little bit here to employment. We're going to talk a little bit about leave laws, the ability to take time off, and then we're also going to talk about non-discrimination laws. So first, let's imagine John. He's a full-time store manager. There are 60 employees at John's branch, and he has been working at his job for about 8 months. John just found out that he has been diagnosed with cancer, and he's not really sure whether or not he's going to be able to continue working during treatment. So what are John's options? Well, there is a federal law called the Family and Medical Leave Act, FMLA, and the FMLA provides up to 12 weeks of unpaid job and health benefit protected leave per year to either take care of yourself or to take care of a covered family member, assuming that you meet all of the criteria to be eligible for this type of leave. So who's covered? So you have to be taking time off for a covered individual. So a covered individual is yourself if you have a serious health condition, or a covered family member. So the law is pretty specific about which family members this applies to. You can take time off to take care of your parents, your children, or your spouse. So the law actually technically says minor children, but it really does apply to adult children as well, as long as the adult child has a serious medical condition that is making them disabled and unable to care for themselves. So if you have an adult child who has cancer, who is unable to take care of him or herself, generally they're going to meet that definition. So yourself, parent, child, or spouse. Now, sometimes we get calls here from people who say, well, I don't need to take 12 weeks off all at once, so I don't want to do FMLA. I only need to take off a couple days here or there. Well, you don't have to take the 12 weeks all at once. FMLA does provide the opportunity to take the time off intermittently, or you can take it all at once. It's really going to depend on your specific situation. Maybe you only need to take off 2 days per month or maybe 1 day per week for treatment. Other people, depending on how serious their treatments are or what their side effects are, what their doctor says, they might need to take all 12 weeks at once. But you do have the option to do either one. Now, in order to be eligible to take FMLA leave, you also have to work for a covered employer. So all public employers, so if you work for state, federal, local government, all public employers are required to provide FMLA leave. If you work for a private employer, it only applies to private employers who have 50 or more employees within a 75-mile radius. So if you work for a very small employer, your employer probably does not have to offer FMLA leave. But if you work for an employer who has several branches or several locations within a 75-mile radius, if the number of employees that work at each of those locations all add up to 50 or more, then they would be required to provide it. Now, one thing I do want to note is that if you do work for a smaller employer and your employer does not have to offer FMLA leave, you still might want to check with HR or look in your employee manual to see whether they provide any sort of medical leave options, because many employers do. Even if they don't have 50 or more employees, many employers still do offer, a certain number. Maybe they'll only offer 2 or 3 weeks, or maybe they'll offer 6 weeks. But, just because the law tells them that they don't have to provide this time off doesn't mean that they don't. They just can't provide less than what the law requires. So always double check to see whether you might have additional benefits. And if you do work for a larger employer, some of those employers offer additional time off beyond what FMLA provides. So, they might only be required to give you 12 weeks off, but some large employers will say, oh, everyone, if you have a serious medical condition, you can take 6 months. Or sometimes they'll say, oh, you can take 1 year. So it really just depends on the employer. Now, you also have to be a covered employee, which means that you have to have worked for that employer for at least 12 months, and you have to have worked for at least 1,250 hours in the last year. So that averages out to be about 20 to 25 hours per week. So, a very strong full-time schedule at the very least, and you have to have worked there for at least 12 months. So is John covered? Okay, and if so, why? So he's a full-time store manager, so he's been working full-time. That probably means that he's got the 1,250 hour requirement. There are 60 employees at his branch where he works, so the employer certainly meets the covered employer prong of FMLA, but he's only been at his job for 8 months. So unfortunately, because he's only been there for 8 months, he probably is not eligible for FMLA leave. He might be eligible for some other type of leave. He could probably still use his sick time. His employer might still offer other benefits for, for full-time employees, but he wouldn't be eligible for FMLA. Okay, so let's switch over here and do another example. Let's imagine Sara. She recently graduated from college and she is a part-time employee at her company. There are 200 employees at her company, and she had gone through some cancer treatments during college, and she's still having some side effects that are still sort of impacting her ability to do her job the way that she might have used to. So she's wondering what her options are going to be in order to continue working. So we're going to go into what some of those options might be. So the Americans with Disabilities Act is another federal law, so it applies in every state, just like FMLA does. And this law was implemented to protect people from discrimination, people with disabilities from discrimination at all phases of employment. So usually when we think about discrimination, we think, okay, well, the person can't be fired for having a disability, or they can't refuse to hire someone just because they have a disability. But when we talk about all phases of employment, that also applies to benefits. It applies to job assignments. So, you know, they basically just cannot treat people differently in the workplace, including hiring and firing, just because they have a disability. So the ADA applies to some employers, so they do have to have at least 15 or more employees. And then in order to be eligible for the protections of the ADA, the employee has to have a disability, and they have to be qualified. So they have to be able to perform the essential functions of the job with or without accommodations. So let's say, for example, that I apply for a nursing position and I have a disability. Well, obviously I might meet that first part of the requirement that I have a disability, but if they fail to hire me, I can't say, well, you know, they just didn't hire me, they're discriminating because I have a disability. No, I also would have had to have been qualified for the job, and it doesn't matter how many accommodations they try to provide me, I can't perform the essential functions of a nursing position because I don't have nursing experience. Actually, I'm going to go back here. So when we're talking about the ADA, you might wonder, okay, well, what is the benefit then? If I do have a disability, if I have you know, a physical or mental impairment that substantially limits a major life activity, that's the way they define disability under the ADA. You know, if I have a disability and I'm qualified for my job, what is the benefit? What do I get? Well, under the ADA, if you're a qualified person with a disability, your employer is required to provide you with accommodations as long as they aren't an undue burden or an undue hardship to the employer. So some examples of reasonable accommodations, and keep in mind that this does vary from job to job and employer to employer, but sometimes, you know, maybe you just need some flexibility with your schedule. So it might be a reasonable accommodation to have you work part-time instead of full-time for a couple weeks. Or maybe you're having issues with fatigue, and so maybe it might be a reasonable accommodation to provide you with a couple extra rest periods throughout the day. Or another example, if you're a cashier, for example, working at a grocery store, and normally you're supposed to be on your feet all day long, maybe a reasonable accommodation would be to provide you with a stool so that you don't have to stand up if you're dealing with fatigue. Or if you have lifting restrictions, that could be a reasonable accommodation. Sometimes working from home can be a reasonable accommodation. But it really depends on what your job is, what your job responsibilities are, and then also, you know, what it is the employer needs you to do and what their capabilities are. Because it's going to be easier for some employers to accommodate people who maybe need to work from home than others. So if most of what you do on a daily basis is at the computer, you maybe do some conference calls, you send emails, you type up reports, that might be something that you could do from home. But if you're working as, again, a cashier, or if you're working as a surgeon, those are the types of jobs you certainly cannot telecommute for. So what is reasonable for one person might be unreasonable for another. It's really just looked at as on a case-by-case basis. So, if you work for an employer that has fewer than 15 employees, there are a lot of states that have their own state fair employment laws that provide coverage for employers with fewer than 15. So, for example, in California here, we have the Fair Employment and Housing Act, which covers employers with at least 5 or more employees. There are other states like Illinois, for example, that have laws that cover employers with 1 or more employees. So basically every employer is covered either by the state fair employment law or by the ADA. But on the other hand, there are some states that just have laws that mirror the ADA. So if you have questions about where your state falls, you can certainly contact the CLRC and we can provide you with that information. So what are Sara's options? Well, the ADA likely applies to her because it said that her employer had 200 employees. She's going to need to figure out her needs to help her do her job. If she's, dealing with some lifting restrictions, or if she's, having trouble concentrating and maybe needs a note taker at meetings, those are things that she's going to have to think about and then request from her employer. Generally, it is the employee's responsibility to request an accommodation as opposed to the employer offering one. So if the employer doesn't know that you need an accommodation and your work starts being affected, that can be potentially pretty bad for the employee, because if they're not on notice, they can take negative employment actions. If you haven't told your supervisor that you need some flexibility and that you might have to come into work late, if they have no idea and you just start showing up for work late, and if the employee or employer policy is that you show up to work late 3 times and you get a write-up, they can still write you up. So that's why it's important to ask for accommodations as soon as you think that you might need them, because then that puts the employer on notice that there's something else going on and that they potentially might have to accommodate you and your disability, as long as it's not an undue hardship to them. Okay, so let's switch gears one last time, and we're going to talk a little bit now about disability insurance. So, we just talked about, if you need to take time off of work or if you need accommodations in the workplace, but for some people, they're not going to be able to continue working, or they might need some income replacement while they're on FMLA leave, because as I mentioned, FMLA is unpaid leave. So, generally people do use their sick or vacation time at the same time as taking FMLA. Your employer can require you to do that, but not everyone has 12 weeks of vacation accrued or sick time accrued. So, we're going to talk a little bit about what the different options are for income replacement. So first I'm going to talk very briefly about private insurance policies and plans. There are some states that have short-term insurance options, and then there are federal programs that provide long-term disability insurance. So let's imagine Sylvia. She did go on FMLA leave while she was going through cancer treatment, and at the end of her leave, she's determined that she's not going to be able to go back and continue to work. But just like everyone else, she still has monthly expenses. She's got her mortgage, she's got her health insurance premiums, her car payments, car insurance. So she doesn't know where to turn for income, but she definitely needs something to help her pay the bills. So private disability insurance is usually something that's offered as a benefit either through work or it's something that people purchase individually directly from the insurance company on their own. Now, we do get questions sometimes from people who say, okay, well, I was diagnosed with cancer. How do I sign up for a private disability insurance policy? Unfortunately, private disability insurance companies and policies do not fall under the same rules as health insurance. So private disability plans can still discriminate based on a pre-existing condition. So once you're sick, it's very difficult to sign up for a private disability plan. And when we talk about private plans, we're talking about various, like Aflac or MetLife. Not that we are necessarily endorsing those companies, but those are some examples. So once you're sick, it's very difficult to sign up. So this is the type of thing that it's a good idea to sign up for ahead of time. And, to be sure about whether or not, let's say that you do have a policy, to be sure about whether or not you actually qualify for benefits under your policy, the devil is in the details. You have to look at what your contract, what your policy says. All, policies vary from employer to employer or person to person. So you really have to look and see, what did you sign up for? What is the definition of disability that they use? Some policies are going to say it's okay for you to be working part-time. Some of them require you to be completely disabled. Their definition of disability might be different from what the definition is under the ADA, which also is different from what the Social Security Administration uses as their definition, which we'll talk about in a minute. So it's really important to have a copy of your policy, to read it through, and to understand what it is you've signed up for and what your benefits might be. The other really major thing that we've seen a lot of with private disability policies is that people are often surprised when they find out that their private plan is going to require them to apply for Social Security disability. It's very common, and usually the private plan only offsets what you would get from Social Security. So let's say your private disability insurance plan says, okay, you're eligible, you meet the definition that we have, we're going to pay you $2,000 a month, but you have to apply for SSDI, and then we'll offset whatever they give you. So let's say you're receiving the $2,000 a month from your private plan, you apply for SSDI, which will, like I said, we'll talk about more in a minute, and SSDI starts giving you $1,500 a month. Well, that probably means you're not entitled to the $2,000 plus the $1,500. Usually the private disability insurance plan will say, oh, well, we were going to give you a maximum of $2,000. SSDI is giving you $1,500, so we're just going to pay the difference. So you'll be back up to that total of $2,000, but we're only paying you $500 a month because SSDI is giving you $1,500. So a lot of people are pretty surprised when they find out that that's actually how their private disability insurance plan works. So if you have a private disability insurance policy, I highly recommend that before you even really need to use it, take a look at what it says so that you know ahead of time, what you're going to be required to do and what your benefits actually are going to be. Now, if you don't have a private disability policy, and those can be short or long-term, some people have both, in certain states, there are state short-term disability insurance programs. So California, Hawaii, New Jersey, New York, Rhode Island, and Puerto Rico have state disability insurance options available for people who work in those states. So for example, in California, our state disability insurance plan is actually run through the same agency that runs unemployment. Now, to know whether or not you're eligible for the state disability insurance, it's usually taken out as a payroll tax. You can check your pay stub to see whether or not you've been paying into the program. And you usually have to have earned a certain amount of money within the last year or within the last base period to be eligible. And then usually there's a brief waiting period. In California, it's 8 days. So they basically don't pay you for the first week of your disability. But in California, the state disability insurance lasts for up to a year, and they calculate how much you are going to get based on how much you've earned during the last year, the last base period. And the same is generally somewhat true for these other states. If you live in another state that is not one of these ones, unfortunately your state does not have a state disability insurance program, but if you have additional questions about short-term state disability, you can always contact us here at the CLRC. So the other option for people who are potentially going to be out of work or unable to work because of their disability for an extended period of time are SSI and SSDI. So these are two separate programs through the Social Security Administration. SSI is Supplemental Security Income. SSDI is Social Security Disability Insurance. And they're both run through the Social Security Administration. So one of the similarities is that they have the same definition of disability. So the way the Social Security Administration defines disability is that you are not performing substantial gainful activity, which basically means you're not working. But the more technical definition of that is that you're not earning a specific amount of money or more. So for this year, it's $1,090. So if you are working and making more than $1,090 per month, they are automatically going to assume that you are not disabled and you're able to work. If you're working and making less than that per month, it's possible that they might potentially consider you disabled, assuming that you meet the other parts of the definition. So you have to be unable to work due to a physical or mental impairment, and your physical or mental impairment has to be expected to last at least 1 year or result in death. So this is not for short-term disabilities. If your doctor says, oh, you're going to be able to go back to work in 6 months, you're probably not going to be eligible for one of these programs. It has to be expected to last for at least 1 year or expected to be terminal. Now, many of you have probably either dealt with or heard of the fact that applying for disability benefits through the Social Security Administration can be extremely time-consuming. Not so much that the application itself takes a lot of time, but that it takes them a very long time to review and either deny or approve people. So we get questions a lot about, okay, is there any way to expedite my application? There might be, depending on what your condition is. And if you have a condition that is listed on the Compassionate Allowances list, the Compassionate Allowances program is a program through the Social Security Administration that is meant to fast-track applications for people who have pretty serious health conditions that are automatically expected to last at least a year or be terminal. So if you have a condition on the list, and you can check out the website ssa.gov/compassionate allowances, then it will potentially fast-track your application so that you get a response within a week or so, as opposed to waiting several months. So some examples, generally, for certain types of cancer, if they are stage 4, if they have metastasized, sometimes those will be on this list. There are other types of cancers such as pancreatic cancer, where it doesn't really matter what stage it's at, it's on the compassionate allowances list, which means that your application would go through faster. So first, let's talk about Social Security Disability Insurance, SSDI. In order to be eligible for SSDI, you have to, meet their definition of disability, an inability to continue working due to your disability. And then how much you are able to get is going to depend on your prior work history. So you have to have paid into Social Security, and generally you have to have worked for at least 5 out of the last 10 years in order to be eligible. And during that time, you have to have been paying into Social Security. So there are certain positions, for example, a lot of times teachers pay into a separate disability fund and a separate pension program. If you're not paying into Social Security, you're unfortunately not probably going to be eligible for SSDI. So they're going to look at your work history, they're going to look at how much you've been paying in, and that's how they're going to determine how much you get each month. And if you're curious about how much you would get, you can create an account online and go on the Social Security website. You can also call them, but probably going online is easier. They did used to send out statements that would say, this is how much you'd get if you were disabled, this is how much you'd get if you retired. I don't think they're sending those statements out anymore, but it is available online or over the phone. Now, SSDI has a 5-month waiting period, which means that you wouldn't start receiving benefits until 6 months after your disability begins. Assuming they approve you, regardless of whether you have a condition on that compassionate allowances list, everyone has a 5-month waiting period. So if your disability begins January 1st and the Social Security Administration agrees, okay, yeah, your disability began on January 1st, even if you have stage 4 pancreatic cancer or stage 4 breast cancer, it's really advanced, everyone has a 5-month waiting period. So your benefits you wouldn't have any benefits for January, February, March, April, May. So you'd get your first check starting in June. Now let's say you waited several months to apply for SSDI because you didn't know whether you were going to be eligible or you didn't know exactly what your diagnosis was or whatever. You can get retroactive payments. So let's say you didn't apply until September. You still wouldn't, if they said that your disability began January 1st, you still wouldn't get any payments for, January, February, March, April, May. But if you apply in September and they immediately approve you, you would get benefits for June, July, August, September, and that might come as a lump sum. One of the benefits of being on SSDI is that after 2 years of being on SSDI, you become eligible for Medicare, regardless of how old you are. So generally, in order to be eligible for Medicare, you have to be at least 65. But if you've been on SSDI for at least 2 years, receiving benefits for 2 years, you become eligible for Medicare. Okay, the other program through the Social Security Administration is SSI, Supplemental Security Income. SSI does not look at your work history. So it doesn't matter if you've been paying into Social Security. It doesn't matter if you've had big gaps in your work history. All they look at is whether you're disabled and unable to work, and then they look at how much money you're making and what your assets are. So usually they won't take into account one house and one car, but if you're an individual and you have more than $2,000 worth of assets in the bank, they're going to say that you're not eligible. So SSI is really for people who are very low income and have very low assets. Now, one of the benefits of being on SSI is that there is no waiting period, so your benefits would start, the following month if they approve you. And you're also usually automatically eligible for Medicaid. So there's no waiting period for the Medicaid either, unlike with SSDI where you have to wait 2 years to get on Medicare. With SSI, you're usually automatically eligible for Medicaid. So you have some sort of health coverage. So what are Sylvia's options? Well, she should look and see whether she has a private disability insurance plan. And if she does, then she should probably see how to go about applying for those benefits. She should work with her doctor to apply for SSI or SSDI, depending on her situation. And the really important thing to keep in mind if you are applying for disability benefits is to emphasize all of the conditions that you have. So sometimes people will say, oh, well, it's the cancer that's making it impossible for me to work right now. But maybe they also have a history of depression, or the cancer treatments have contributed to making them depressed. Maybe they also have a history of having a bad back. They have other chronic conditions, diabetes, whatever. It's really important to make sure that all of that is included in the application, because you really want them to have a good picture of your entire medical condition or mental health condition, so that they can really judge whether or not you're actually able to work or go back to work. So it's a good idea to talk to your doctor if you're thinking about applying, because sometimes you'll go to the doctor and they'll write stuff into your medical record saying, oh, she's doing so much better and she's doing really great. And that's a wonderful thing to hear from the doctor, but it's not particularly helpful for an application like for SSI or SSDI. So it's a good idea to talk to your doctor so that they're aware. Okay, so what are some of today's takeaways? We talked a bit about health insurance, we talked about employment rights and disability income and how they all fit together. So I know we're right at 1 o'clock here. I'm going to stop the recording now and see if I can try to spend maybe a couple minutes answering questions.